anyone has any questions, you can raise your hand.
Well, a very brief comment. I first of all like to compliment both the speakers for very succinct but very insightful presentations. I just had a comment about Jan's presentation. Uh, the QR's case which we lost, and I think it is important to look at it in a systemic way. We may have lost the case, but we won the war because the QRs when we had to implement the decision, we liberalized our economy, and the Indian economy benefited enormously from that measure. So I think when we look at WTO disputes, we also need to look at, as Jayant pointed out, at the curative value of certain orders from the WTO. The second point, which is just a brief comment, the entire issue of zeroing, about which the United States is very much concerned with, it started with with an Indian case, an Indian dispute in EU bed linen, which we won in both the panel and the appellate body. Both of them upheld our complaint that the practice of zeroing was wrong.
Solutions have worked for India. Like if we talk about the recent 7 disputes, which I already asked you during our telephonic conversation. So can you just briefly summarize that in 2 minutes about all the 7 disputes, how beneficial they are for India to enter into mutually acceptable solutions? As we know that for some of the disputes, the inconsistent measure is not been removed, it's still at place. So what was there for India to gain out of those disputes, sir?
That's a very interesting question, very important question as well. Well, in any matter like a dispute, you can't always gain 100% success. So it'll be a kind of measured success in some areas and not so quite successful in other areas. When we removed this, or we compromised on this chicken legs issue, on this avian influenza case which had been filed in 2012, we reduced the duties in other areas like blueberries and blackberries and a few other agricultural items, within the sector of, broadly speaking, agriculture. So, in a sense, the principles, because we were unable to establish scientifically that avian influenza, the case that we had made out for not allowing to import US chicken legs from the US, was not based on a sound footing. The OIE, which is the apex animal husbandry and animal health organization, intergovernmental organization in the world, had said that this high, there are two kinds of avian influenza. One is the one which kills birds, and the other one infects birds but does not kill them. So I think high pathogen or something, avian influenza, was not prevalent in the whole of the US. And the US had been able to show that they were culling birds wherever it occurred. So we were unable to establish our case. There was no way we could have complied but to have allowed chicken legs to be imported. So we refrained from doing that, but compensated them in some other way. So that was the best possible solution. So I'll stop at that. The other cases also, we have compromised in a similar manner. Incidentally, Professor Sharma, strictly speaking, within the four walls of this hall, I had advised the government not to pursue. Sorry. It's live streaming. It's all right. I had advised the government not to pursue the case because we didn't have much of a case to fight in avian influenza, as well as on the solar mission matter.
Thank you so much, sir. I think with that, we will begin with the valedictory ceremony. We are also joined by Professor P.S. Rao. Um, The importance of unity in times of calamity can be traced to the Titriya Upanishad, written in the 6th century BC, which says, Navavatu, Nava Bhunaktu, Viryam Karvate Vahe, meaning, may we together be protected, may we together be nourished, may we together work together in great energy. As we gather here from various corners around the globe, representing diverse backgrounds, expertise, and perspectives, we are united by a common goal to address the pressing challenges facing the trade landscape and to seek viable solutions that uphold the principles of fairness, equality, and justice. Over the past couple of days, we have engaged in rigorous discussions, exchanged valuable insights, and chartered new pathways forward in navigating a complex terrain of dispute settlement within the WTO framework. As we embark on this final leg of our journey, let us reflect together on the collective wisdom gained, celebrated in the shared virtue of collaboration and innovation, fueled by the deliberations that reaffirm our commitment of forging more resilient and inclusive international trading systems. For the prosperity of all nations. Now, I request Professor P.S. Rao to address the gathering.
Thank you very much for giving me the floor on this last leg of our two-day excellent gathering of experts on a matter of very contemporary and very current interest. That is the work of the WTO and the central role being played by the dispute settlement mechanism. It has been well known that the dispute settlement mechanism was a product of its times, and it came through and served the interests of the WTO and international trade for a long time very well. A number of important decisions have been rendered by the WTO appellate panel as well as panels themselves, and they have become so central to the success of the WTO trading system that we cannot think of now a World Trade Organization work without an appellate body being working there. But the time has come where this has become a reality, and for the last several years, number of proposals are being made to revive and reconnect the roots of this dispute settlement mechanism to the current realities. However, the current realities have multiplied in terms of not only urgency but also in terms of the range that they are that they have to impact upon not only trade but the entire world order itself. Under the circumstances, the negotiations that are taking place with respect to dispute settlement mechanism cannot be seen in isolation, and they have to be seen in the totality of the broad objectives for which the world order and the rule of law itself has to be really be aimed at and then worked at. Rule of law in the international system was helped largely by the UN Charter itself in 1945, and of course much later by several other institutional mechanisms, and most importantly WTO itself. Because trade is the center of all international not only economic development, but also trade is at the root of all international relations, etc. For your information, and I don't have to say this, colonialism is a product of the of extension of European trade interests to the worldwide areas, to the remote areas of the world, and that's how the colonialism survived, and it defined the very basis of international relations for a number of 400 years. But that has gone, and now we have a multipolar and more inclusive society, um, and a global interconnectivity, globalization, if you want to call it, has become a reality. It is something you cannot wish away, even if you don't want it. It's going to impact us. Like, for example, Ukraine war, like the Israeli Gaza, the Hamas conflict that is taking place, and the wider the implications of this, both for trade as well as for peace. Under the circumstances, can dispute settlement mechanism be discussed and debated and otherwise designed anew under the in the new context, without having to really work at the basics of the trade principles themselves, which are at the root of the conflict themselves, whether it is China versus American competition, whether it is Europe versus China and other issues, or whether it is artificial intelligence and the ever-growing influence of cyber security, etc. Other things are going to impact. How they are going to impact is going to be central to the dispute settlement mechanism ultimately also. So under the circumstances, to expect quick results, to expect comprehensive results, to expect a kind of a fundamental reform, perhaps maybe a bit too much to ask, but we have to work at it. We have to find out what is more amenable for quick resolution and what is should be resolved in course of time. We'll have to sort out these issues. I think this two-day seminar has helped us to identify some of these problems. And India as a economy, which is now not only very well grown up and also very crucial in terms of any alternatives that are going to be developed, its own interest will have to be certainly be projected, and projected with a sense of unity and inclusiveness, rather than like some others are arguing, their country should come first, their interest should come first. In fact, in a world in which is so integrated and so interrelated, no one can claim priority, and all of us have to work together. And that means inclusivity, common interests, and rule of law will have to be the basis on which we all have to subordinate our private interests or personal interests or otherwise special interests, as they call it, to a more broader goals of climate crisis, poverty alleviation, more social justice in terms of distribution of wealth and means of production, etc. All these things will have to come into play. So that means a broader agenda is ahead of us. So under the circumstances, our center, the kind of conference that we have gone through for the last 2 days has really opened up several new areas of investigation, and my own mind is very much charged with several ideas, and I'm sure with our colleagues and all of you participating in this common venture through the center and otherwise also with collaboration with other important institutions, we should be able to move forward on some of these issues, if not all of them. So we'll prioritize our future work in terms of what kind of areas we should investigate. But I think we should now come out with one clear thing. One thing is very clear: that dispute settlement mechanism is not an independent issue. It has to be looked at in a comprehensive context of global trade and world peace itself, and then we have to identify some priority areas which are fundamental and crucial to world peace and rule of law, and then promote them. And this would be my endeavor, and with my colleagues, we have wonderful colleagues in the center now, and with all the expertise that we've been able to gather, I hope we'll move forward and make a grand success of at least some of the areas in which we will contribute. I thank you very much for all your efforts, and I now give the floor to Kapil Sharma to identify as part of this whole seminar what are the takes that we can, what are the good takes that we have on this matter. In other words, what are the main items that he thinks that we have been able to achieve, and look forward to take further action on that. Thank you very much. Captain Sharma, you may have the floor.
Thank you so much, sir. Ladies and gentlemen, esteemed guests, esteemed delegates, and distinguished guests, it is with great honor and privilege that we stand before you today as we culminate this extraordinary gathering, the International Conference on Crisis and Solutions to Dispute Resolution System under the World Trade Organization, in collaboration with the Center of WTO Studies, Indian Institute of Foreign Trade, New Delhi. This valedictory ceremony is to acknowledge the efforts of each of the respective panelists, participants, college authorities, OC members, volunteers, members of this BP Jeevan Reddy Center for International Trade and Business, and every functionary that contributed to the successful conduct of this conference. I am Skandita Tiwari, and this is Ayush Singhal, and we will be hosting the valedictory ceremony on behalf of the organizing committee.
In realms of trade where passions flare, crisis grips with its relentless glare. In the heart of commerce, tumult brews. Yet, 'tis in chaos, love still ensues. Beneath the stars of global sky, merchants weave their dreams through troubles nigh. Through stormy seas and tempests wild, their ardor burns, untamed and style. In every crisis, a tale untold, a tale unfolds of resilience and hearts set bold. For in the crucible of trade's embrace, passion stir a boundless space. Dispute is the first step towards growth. JFK once pointed out that the word for crisis in Chinese, weiji, is composed of two characters, the former meaning danger and the later opportunity. Crisis management and dispute settlement are the twin pillars upon which the stability and effectiveness of the global trade architecture rest. In an era marked by unprecedented economic interdependence and geopolitical complexities, the ability to swiftly and effectively address crises and resolve disputes is paramount to preserving the integrity and credibility of the World Trade Organization. As we deliberate on the challenges and opportunities ahead, let us reaffirm our commitment to strengthening crisis management protocols and enhancing dispute settlement mechanisms within the WTO framework, thereby fostering a climate of trust, cooperation, and prosperity among nations.
Good afternoon, everyone. I'm Anirudh Bandla, and as head of the organizing committee, I extend my heartfelt thanks to everyone involved in making this conference a success, to our esteemed panelists, participants, university authorities, and most importantly, without whose efforts and hard work, this event would never have been possible, the volunteers and the members of the organizing committee. I would request you all to give a huge round of applause for the volunteers and the members of the organizing committee. Together, we've showcased the power of collaboration and dialogue in addressing global challenges. I'm confident that the insights gained here will drive meaningful progress in dispute settlement systems under the WTO. Thank you all for your dedication, commitment, and active engagement. I have a small announcement before I hand over the podium to Mr. Aditya Tripathi. The certificates of participation for the participants will be distributed after the valedictory. Now I'll hand over the podium to Mr. Aditya.
Thank you, Anirudh. As the hectic but intriguing 2 days conference on crisis and solution to dispute settlement under the WTO comes to an end, I'm here to give a brief on what we had in the past 2 days. The conference was divided into 3 panel discussion sessions, 2 plenary sessions, and 9 technical sessions. The topic for the first panel discussion was From Crisis to Consensus, Innovating Solutions for DSU Revitalization. We had Ujjal Singh Bhatia sir, Professor Werner Zudok sir, Professor James Dabra sir, Mr. Atul Kaushik sir, Professor Sheila Rai ma'am, and Professor Shelja ma'am discussing on the issues which have caused a standstill in the body. The discussions were made on the Marco Molina process, perspectives of developing countries on the current crisis, whether there should be a single tier or a two-tier dispute resolution system on strengthening the also on strengthening the alternative dispute resolution mechanism for effective resolution. On all these arguments, were realized on the theoretical and practical perspectives on the basis of previous negotiating experiences. The panel discussed on fostering innovative solutions for the revitalization of the body for the smooth functioning. The topic for the second panel discussion was demystifying the ongoing WTO crisis and the way forward. We had Professor Laila, Mr. Atul Kaushik sir, Mr. Jayant Das Gupta sir, Professor Abhijit, Professor Varnes Zudok sir for the session. The session started with a discussion on the climate justice and explained China's challenges because of the US Inflation Reduction Act. There was a discussion on Doha development agendas. There was discussion about India's offensive and defensive interest and how the interest of developing countries should be protected. Few way forwards, as discussed, were enhancing the capacity building and legal advice assistance for the developing and least developing countries in the pursuit in pursuance of the Article 27.2 and 27.3. Second, establishment of a dispute settlement fund for the effective dispute resolutions for developing and least developing nations. Also, letting developing nations and least developing nations act as a third party and have the third party rights. Since the DSU at the present is in a paralysis, the WTO DSP is moving towards delegalization and judicialization, because of which the governments are moving towards alternate dispute settlement as a medium of dispute resolution. Panel discussion 3 was on the topic navigating the future of dispute settlement, global priorities, and changing the world order. We had Mr. Ujjal Singh Bhatia sir, Mr. Jayant Das Gupta sir, Mr. Atul Kaushik sir, and Professor Varnes Zudok. The session started with a question that even if the dispute resolution system is reformed, whether still it can perform its function due to the changes happening in the international geopolitics and technology, as it has become to form a single dispute resolution systems for all these matters. Discussing about the MPIA, the multi-party interim appeal arbitration arrangement has its own shortcomings, such as its membership is restrictive and countries like China being selective about disputes to be referred to the MPIA. Hence, it's time to rethink on the dispute settlement and address the paralysis of rulemaking in the WTO. A multidisciplinary approach needs to be evolved in India. In Indian context, a case by case assessment on how to handle each dispute needs to be addressed in the present rulemaking form. Coming to the technical sessions, we had 9 technical sessions and over 60 papers being presented in those sessions. We had intriguing discussions on why there is a crisis and what can be the way forward. I hope this conference has helped us all to for new perspectives and an understanding of WTO. Thank you.
Now I request Vice Chancellor Sir to hand over the mementos to the panelists. First, we have Professor Leela. Now we have Mr. Ujjal Singh Bhatia. Now I request VC Sir to honor Professor Werner Dock. Now I request VC Sir to honor Mr. Jayant Das Gupta. Now we request Sai Ramani ma'am to collect her momentum. Thank you so much, everyone. With that, we wrap the valedictory ceremony. I request Rosmi ma'am to come and address to give the vote of thanks.
A very good evening to one and all present here. We have reached the closing phase of the International Conference on Crisis and Solutions to Dispute Settlement System under the World Trade Organization. During the last 2 days, we explored into the need for improvements in the functioning of the WTO's dispute settlement system, with an emphasis on the ways to overcome the 4-year impasse on the appointment of new appellate body members. To quickly summarize the appellate body crisis, the central theme of this conference: since 2017, the United States has been blocking the appointment of new judges to the appellate body, citing concerns about its overreach, delay, and lack of transparency. As a result, the appellate body has been unable to function since December 2019, leaving many disputes unresolved or unenforceable. As we understood, the WTO needs to find a way to break the impasse and restore the appellate body's role and legitimacy. It also needs to address the underlying issues that have caused the dissatisfaction and distrust of some members. This may require some reform in the selection, tenure, and conduct of the judges, as well as in the procedures, standards, and the scope of the appellate body review. The conference critically analyzed the appellate body crisis and evaluated the reform from all possible dimensions and listed out the potential challenges associated with various proposals and actions. We could do this exercise only because of the wisdom and experience of our resource persons. We are indeed very grateful to all our resource persons who are the best ones to talk about the appellate body crisis and the way forward. I take this opportunity to place on record our sincere thanks to Ambassador Ujjal Singh Bhatia, Professor Varnak Sudok, Professor Peter Vanden Bosch, Ambassador Jain Das Gupta, Professor Shaila Chukron, Mr. Adul Kaushik, Professor James Nerdambara, Professor Sai Ramani Garimalla, Professor Sheila Rai, Professor Abhijit Das, and Professor Shailja Singh. We also extend our heartfelt gratitude to the technical session chairs and co-chairs, Dr. Anwesha Pal, Ms. Tuti Toshi, Ms. Tanvi Praveen, Ms. Tista Lahiri, and Ms. Divashri Suri. We are extremely thankful to our colleagues, Professor Srinivas Subbarao, Dr. Hemangini Sharma, and Dr. Bayola Kiran for rendering us the timely support. This conference would not have been possible without the support and guidance that we received from the Center for WTO Studies, Indian Institute of Foreign Trade, New Delhi. We sincerely thank Professor Preetham Banerjee for the collaboration in his absentia and request Ms. Tisa Lahiri to accept our thanks and gratitude on behalf of CWS. Let me put on record our tributes to our Vice Chancellor, Professor Sri Krishna Dev Rao, for his guidance, encouragement, and providing a stimulating environment for educational development adhering to the best standards in the world. Thank you, sir. A big thank you to Honorable Justice B.P. Jeevan Reddy for gracing the inaugural ceremony and motivating us to be the best research center in the area of international trade and business laws. I wish to express our profuse thanks to our director, Professor P.S. Rao, for his constant encouragement and guidance. He was kind enough to make him available virtually throughout the conference and giving us timely tips over phone, ensuring the smooth conduct of the conference. Thank you, sir. I would also like to take this opportunity to place on record our sincere thanks to the registrar, Professor Vidulada Reddy, for the perfect administrative support and guidance she has extended to all of us in the organization of this conference. I also extend my thanks to the IT department, store, account section, and also to the support staff for their enormous cooperation in the organization of this event, and also for their willingness to work on holidays. An event like this cannot happen overnight. The wheel starts rolling days ago. It requires planning and a bird's eye for details. We have been fortunate enough to be backed by a team of very motivated and dedicated student volunteers of Justice BP Jeevan Reddy Center for International Trade and Business Laws, who know their job and are result oriented. Let me thank the entire organizing team for their dedication, teamwork, and untiring efforts that they have put into making this conference a huge success. The secret behind the success of this conference is nothing but the vision and intelligent work of Dr. Kapil Sharma and the support he got from my colleagues, Ms. Elekia A. and Mr. Aditya Tripathi. It's my pleasure and privilege to congratulate them for the success of the conference. Congratulations and thank you, dear Kapil, Elekia, and Aditya. Dear participants, I thank all of you for your attendance. All of you are briefed on the latest developments in the ongoing informal discussions on dispute settlement reform and what we could expect in the future to some extent. There are great times ahead of you. Country needs your service. Each one of you is needed in your country, community, and university to ensure quality scholarships and knowledge sharing for the creation of a well-informed and well-resourced working group which could find solutions to the present and future international legal problems. I urge all of you to make use of the knowledge and resource that you have acquired during the conference and to share it with your peers and colleagues. I would like to end my vote of thanks with a grand applause for everyone present here. And I declare that the conference is closed. Thank you.
Thank you so much, ma'am. With that, we conclude this conference. Just a small reminder, the participants can collect their certificates from the desk outside. There'll be Kirti. She'll be sitting there. You can collect it from her. Thank you so much, everyone.